Thanks for being here tonight. I think we will start some housekeeping before we start. And let me just move myself out of the way. I can make myself a bit bigger. So just a quick note, type the questions into the chat and click anywhere on the screen to activate and tap on chat. Now, I know Surendra has been test driving all the icons. So if you're on a phone, you tap on the screen and then your chat should be at the bottom of the page. It's got a chat icon like that one. I'm in mirror image, so I don't know where I'm pointing. If we lose connection, or if there's a problem with the sound, then just let me know. So if we lose connection, just disconnect and use the same link to come back in again. So the purpose of today is to break down the Renters' Rights Bill and its impact on landlords and property investors. And why? I think because there's housing shortage, so it's always high on the agenda. Anything to do with housing is always high on the agenda. So our agenda today is the Renters' Rights Bill and how to prepare for it, some Q&A, and then we'll have how to buy and sell property with tenants in, and we'll have a final Q&A. Hopefully you can stay the whole time. Now, at the moment, the Renters' Rights Bill is between the House of Commons and the House of Lords, and it's known as the ping pong stage. So it's back and forth between the houses until they agree. Now, the government isn't very in a ping pongy type of mood. So the government is not in a very ping pongy type of mood. They just decline everything. There is one hope, and I'll deal with it when we go through it. So a little bit about me and the company is that I'm Bridget. I'm the owner of Gateway Property Hub. We're here in Croydon, South London, if you don't know where sunny Croydon is. And I've got 30 years of I've got 30 years property experience with the company. So it's 2006, this company. So next year we'll have our 20th anniversary. So we'll have a whole load of events for tenants, landlords, live events. I don't know, anything to have a bit of a party. And we do the whole cycle now. So when some of you met me, I only did lettings. And then over the years, as the need arose, we moved into block management, fire risk assessments, renovations for landlords and vendors. And now we do sales when people want to sell and move away, or we do sales with tenants in it. We do sales for landlords as well. I've always had a love for property. So my dad was self-building a new house in South Africa when I was about 7, and me and my brother and my sister were always going around on the builder's wheelbarrow and building sand and creating havoc while my mom and dad were trying to measure up and plan where the fridge is going to go. To this day, I'm still very much into renovating, and if I see a property, I can always see the things that we can do with it. So our office did mostly tenancy management and block management, but then over the last 5 years, we dived into sales. So we've got a vast variety of staff, and a lot of them, we are accredited members of the NRLA, National Residential Landlord Association, and the London Landlord Association. And the staff, ALA and MALA, qualified in readiness for all this legislation that never arrived. So lettings is not just to collect the rent and fixing the boilers. We must be fully familiar with all 179 pieces of legislation. I can't believe it, because when I started 20 years ago, there was hardly anything. And now we have to do the right to rent, and you must check that the smoke detectors and the carbon monoxide in the right place. So things have changed so much. Okay. So the Renters' Rights Bill, it was called the Renters' Reform Bill. And then it went through all these iterations and eventually went to Parliament. And then when the elections were announced, they just had to cancel everything, all the progress that they'd made. And then the new government came in, and then they said, oh, let's call it not the Renters' Reform Bill, we'll call it the Renters' Rights Bill. Scotland went through a similar thing, but they implemented things quite quickly and recovered. This red line is Scotland, and we're still plugging around the bottom here because people just can't make up their minds. So in essence, it'll really be good if we just get some clarity regarding this whole Renters' Rights Bill. So we're trying our utmost to thrive under the Renters' Rights Bill. By you being here is already a sign that you are not a rogue landlord, because this whole Renters' Rights Bill is supposed to be aimed at rogue landlords. Now, rogue landlords are not going to join us. Now, we've got a good mix of people here. We've got property investors, we've got wannabe property investors, we've got homeowners that are thinking perhaps of renting their home, we've got experienced landlords, beginner landlords, portfolio landlords. So we've got them all. So you're definitely not rogue landlords if you're here tonight. This Renters' Rights Bill is driving reform. It's just politics and public pressure and housing crisis. We'll be covering the key changes under the Renters' Rights Bill, the EPC, decent home obligations, and all that. And just the next slide, I can't think of two things at the same time, so apologies for that. I'm just going to do a quick poll, and you just select the ones that you're worried about. Let me just figure out how do I do this poll thing. Launch. So you should see on your screen a poll. So I'm going to share the results with you. So basically, eviction of tenants, most people are worried about. And then the rent increases, maintenance, and can I sell with tenants? Yes. So actually, it's quite evenly distributed. So the recent amendments there are no real recent amendments. It's not been finalized. So if you're thinking, I was hoping, I specially arranged this webinar so we could hopefully have some final results of what is decided. And unfortunately, it's not been finalized. It's sort of getting there. King Charles was going to be signing it off at the end of May. He didn't. And now they're hoping by the end of October, but it's not been finalized, and there's still some ping-ponging going along there, in suggestions are being made, and then they just get thrown out. So it's down to understanding the laws, and the EPC is not part of the Renters' Rights Bill, and they're aiming this to be part in 2030. So the current government, they've said, oh no, we're not going to do it in our lifetime. If they get chucked out of government, then they'll leave that legacy for the next government. So I think it's a lot of political gameplay, all these things. So security of tenure. Now, what is security of tenure? I had to go look it up because some of these words are a little bit posh. So what is security of tenure? It's basically preventing a landlord from evicting tenants without a valid reason and a court order. That's in very short. Like in the olden days, people just got chucked out of their home because they didn't clean their windows. The landlord drove by, and if he didn't see the windows were clean, then he just chuck them out on the street. So that is not possible. Security of tenure. So fixed term tenancies are going to be abolished. Now this sounds quite scary. So there's not going to be a 6-month anymore. There's not going to be a 12-month anymore. There's not going to be a 24-month tenancy anymore. There's not going to be any tenancy anymore. It's all going to be periodic from day one. And that's definitely coming. So we will not be able to sign up tenants for 24 months and then you say that property's taken care of for 24 months, because the tenant can basically give notice after 1 day. Tenants can leave at any time, giving 2 months notice. So if he moves in on day 1, on day 2 he gives notice, he has to stay until a full 2 months have gone by. So then he's lost month 1, so he'll have to leave at the end month 3. And in the beginning I thought, oh no, that is so terrible. But most tenants are not going to be leaving after 3 months. It's so expensive to move, install your broadband, moving, having all your insurance changed, your vet changed, your NHS, your doctor, all that. So it's only a few that are going to take a chance. Like the first worry about that when we heard that was, oh, they're going to rent our properties and start Airbnbs. But they'll have to put furniture in, they'll have to put everything in. Good luck to them if they want to do it for 2 months. It's just not going to be feasible. And then there's not going to be fixed term tenancies after the commencement date. So current stuff will stay as it is. So if you're in the middle of a 24-month or a 12-month tenancy, then don't worry. When the commencement comes, and it could come any day, there will be no more fixed term tenancies. It'll all be periodic from day 1. But your existing stuff, don't worry about that just yet. So periodic tenancies will replace fixed term tenancies. There's not going to be any fixed term, 2 months notice from day one, rent payment date is fixed. So that is going to be quite difficult for some tenants, because I know some tenants, they say, oh, I moved in on the 1st, but I'll get paid on the 15th. Could we make my payment date on the 15th? And I'll pay you the 15 days and I'll pay for 1.5 months. And then my pay date and my rent payment date is all in sync. You won't be able to do that. You can only take 1 month's rent up front at any time. You cannot take 1 month and 1 day. You can only take 1 month at a time. So that also bans the rent in advance. So if you've got a tenant that's got a bad debt, CCJs, then they usually say, look, I've got a CCJ, but I can pay you 6 months up front. And then some landlords accept that. We don't, but some landlords accept that. That won't be allowed anymore. So actually tenants will suffer under this renters' rights bill. And in your tenancy, you're not, and there's going to be like whole new tenancies. You can't use that old AST that you've got hidden in the drawer or photocopied from the bookshop. You have to get this totally new tenancy agreement. It's not going to look anything like we know. And there's not going to be allowed any rent increase clause as well. You can't, because it's a periodic. So there's not going to be after 12 months, it's going to have inflation or anything like that. So just to summarize, removal of fixed term tenancies. All tenancies will be periodic. The tenant will need to give 2 months notice, which needs to be in line with the rental period. And there's a 12-month protected initial period. Now I'll come to that in the next point, but just keep that in mind. The end of section 21. Now that is, I know a lot of you have said that is one of your concerns, and it's the end of no fault evictions, because they've always believed that we as landlords love kicking our tenants out to get a higher rent. Let me tell you, it's just not worth it. Because if you kick your tenant out, it might stand empty for a month and it's going to cost you a fortune just to get a new tenant, and the inventory and the right to rent checks and all that. So it's really not worth kicking a tenant out. There's usually a good reason why you want him out. But landlords can still get their property back if they're selling or moving back using the amended Section 8. The Section 21 is going to be gone and everything is going to go on to the Section 8. And Section 8 is just an eviction. So for somebody who doesn't know what Section 21 is, it's just an eviction form that's called Section 21. And now we've got an eviction form called Section 8. If there are investors in there that haven't bought a property yet, this is the lingo of landlords, Section 21 and Section 8. So the end of no-fault evictions. So Section 21 was the no-fault eviction. And it was really, it's just saying, could you please move? I'll give you 2 months notice for no reason. But this is not the end of fault evictions. So non-paying tenants and antisocial behavior will still be able to be dealt with under the normal Section 8. It'll be slightly changed because they have to add a whole lot of grounds. So they're going to be adding grounds to Section 8. One of the grounds is going to be sale of a property. You need to give your tenant 4 months notice if you want to sell a property. So if your tenant moves in on the 1st of January and his tenancy ends at the 31st of December, you need to give him 4 months notice. Now, we don't know the exact details, but we think it's probably going to be 4 months before the end of December. You can give him notice to move out on month 12, but you must give him 12 months of uninterrupted staying. But the big thing is now, if you cannot sell it, so you say, okay, tenant, please go, and tenant moves out on the 31st of December. So you put it on the market for a month or 2 or 3 or perhaps 4, and if it's not sold, you cannot relet it. You cannot put it on Airbnb for 12 months. So a whole year must go by before you can. So you have to really think carefully. Do I really want to sell it? So that's why we came up with a solution. Well, it's an old solution, but we just thought, if a landlord really wants to sell, it might be better if he sells it with a tenant in. That is, if it's a good tenant. And yeah, so there are all sorts of what ifs. but you cannot relet it if it doesn't sell. We were hoping, and I know part of the ping pong phase was that they'd give us 6 months, because if you put the property on the market for 6 months and it hasn't sold, then surely you should be able to relet the property. But yeah, anyway, so we'll see what happens. So that's the sale of property. And then occupation by landlord or family. So that is another reason why you would be able to ask the tenant to leave, is if you as a landlord or the family of the landlord wants to move in. Now, at the moment, it says landlord, wife, civil partner, parents, kids, grandkids, brother, sister. Doesn't mention anything about cousins. So I don't know, brother and sister, what about their kids? So we'll see what the law actually specifies once it comes out, so we can see how reasonable or unreasonable it is. Because surely if your niece wants to move in and you've got this house, then surely you should be able to give her that house to live in. So the changes to the Section 8 grounds for possession, so that's still for serious rent arrears, at least 3 months rent arrears. So at the moment, it's 2 months rent arrears. Now, it's going to be from 2 months, it's going to go to 3 months. So that's 50% more. And then on the current regime, if you have a tenant that's 2 months in arrears, you then give him notice, and then within 14 days, you can go to the court and ask the court to start. Under the new stuff, it is 3 months in arrears and then 1 month, so 4 weeks before you can apply to the court. So that's double the time, basically. So that leaves you 4 down. And that's why we tell all our landlords, please, please get rent and legal cover. And we've got some of our landlords here. I know 1 or 2 of you are very happy that we actually insisted on that, because not all tenants, you have a good run and then sometimes you have a patch of bad ones. And especially with people losing their jobs, you just don't know what happens in their lives. Now, for student HMO landlords, there's a special compensation. You can give them 4 months notice. You don't have to move into it yourself or sell it. But for other tenancies, you can't really get rid of them unless you're selling or they're in arrears, or if you want to move back. So I think a lot of people are going to be moving back to their properties. Also, new grounds for possession, for example, agricultural workers, ministers of religion, supported living and social housing. Now, you can understand why, because it's not really Housing Act that, because agricultural workers, the farm belongs to the farmer. He's providing some homes for his workers. If they leave the job, then surely you should be able to get rid of them. And the same with the minister of religion. If he gets fired for any reason and you can't have him living in the church house, and then the new minister is stuck living in a shack somewhere. So supported living is all people that have to meet certain criteria. So if somebody needs supported living because he's unable to do certain things, but then he recuperates and becomes able, then surely that charity should be able to say, listen, you can now look after yourself, so please go. So there are some exceptions to the rules. There is a new procedure as well for increasing the rents. And landlords will only be able to increase the rent once a year. At the moment, it's like that anyway. Once a year, by following the Section 13 procedure. Now, I know at the moment you can write to the tenant. I'm going to play you a video of my colleague in a minute, and she'll explain it to you while I have a sip of water. But you need to issue Form 4 to the tenants, and you must give 2 months' notice. So under the current way of rent increases, you have to give 1 month's notice. But with the new legislation, you'll have to give 2 months' notice, which I suppose is not too bad, and must expire at the end of the rent period. So that doubles the rent increase notice. But the tenants will be able to challenge the notice free of charge. Now, they can do that currently at the moment, and they can, and then the first tier tribunal can also reduce the rent if it's above market rent. There's no rent cap, so don't worry, there's no rent cap, and there's no rent cap in market rent. The first tier tribunal will look, if your increase is above the market rent, they will decline it. They will suggest that it comes to market rent. But the big problem here is the rent increase won't come into effect until after the tribunal makes their determination. I don't know how long that queue is going to be, because the first tier tribunal is now dealing with a whole lot of, I mean, if I was a tenant, I would obviously complain about my increase, even if it's £5, and hopefully kick the ball forward so that it takes 4 to 6 months to do this. How is market rent established? That's a good question there. I will answer the questions in Q&A, but I just saw this one out of the corner of my eye. That is just basically doing a good market research and seeing what is available on the market in comparison to the property that you have. Now, what we always do, we always make sure that a tenant that's been there for a long time at least has the benefit of having a little bit of a reduced rent. So we never really take it up to market rent. But I don't know how they're going to determine this market rent, and let's hope it's not this Bureau of Statistics or whatever they want to call themselves, because I don't trust them. And then the first tier tribunal can delay the start of the new rent by a further 2 months in the event of undue hardship. Now, if I was a true crookie tenant, I would say I am undergoing severe undue hardship and see if I can delay the rent increase by even longer. Now, this is my colleague. I have to share the video file of Hema talking about the rent increases.
There's going to be a few changes that you want to be aware of, because you need to comply with the new laws that are coming up. We need to do market research to find the right rent that a property in a particular area should be paying. You need to keep records just in case the tenant appeals and this ends up in tribunal. You need to be able to prove that you have done the right market research. You need to issue a formal document, and this has to be a form called Section 13. The notice period to issue a rent increase is going from 1 month to 2 months, which means that if the rent is due on the 1st of January, you have to give the notice by the 31st of October. For all the old tenancies where there are clauses about rent increases, that is not going to be able to be used anymore. All tenancies are going to become periodic, and they won't be able to have any rent increase clause. You can only issue one rent increase every 12 months. Once you have issued a rent increase, your tenant can actually go and appeal to the tribunals. If the tribunal decides that it's not a fair increase, they will at whatever they think is reasonable, and that new rent will only apply from the day the tribunal sets rather than the day you issue Section 13. When there has been an appeal with Section 13 that you have issued, you need to be aware that the tribunals can no longer issue a higher rent increase. They can keep it as you issue it, or they can lower it, but they are never going to go up, just to protect the tenants. To summarize, things to remember about the rent increases moving forward: you need to do your market research and document everything you have done to get to the figure you are issuing the tenant. You need to do a formal document called Section 13 issued to the tenant with the new information about the new rent. Number 3, the notice has to be 2 months instead of 1 month. So please be very mindful with that. Number 4, you can only issue one rent increase every 12 months. For private landlords, if you haven't got an agent that can help you with these rent increases, we offer those services just to make sure that you're keeping within the law. There will be penalties of up to £30,000 for landlords not complying with the new laws and regulations. So please be aware, be mindful, and if you are not sure, ask us. We can help you. If you have any questions, go into the comments.
So that was the rent increases. And like I said, you serve the Section 13 notice every 12 months if you can, and 2 months notice. And it's quite important that you increase those rents, because if you don't increase the rent, then if you want to sell it to an investor, that's what they're going to be looking at. They're going to be looking at what rent you're getting. And when you want to remortgage, they're going to look at what rent are you getting. Buy-to-let mortgages, they don't look at your income. They look at what the rent yield is of that property. So remember to put the questions in the chat. I've got some questions already, so thank you very much. And the next is the ban on encouraging, inviting, or accepting rental bidding. So landlords and agents must specify the proposed rent in writing, so either on the listing or on an offer. And you cannot take a penny more. You can't accept it. And even if you do a viewing and you have 10 tenants and the one thinks, oh, I'll offer £25 more, You cannot encourage them or invite them. I think we'll be wearing body cams one of these days, because these tenants are going to take everybody to court. How do you prove in court that you actually did not encourage them or invite an applicant to offer a higher rent? So the civil penalties are up to £7,000 for the initial breach, and that can increase to £40,000 for subsequent breaches. Now, this is never a practice that we've ever done as a letting agent. We've never encouraged higher offers. But if a tenant has got a dog, then we say, look, you've got a pet, therefore you need to pay £25 or £35 or whatever we decide how big that dog is. You need to pay extra because there's going to be extra damage, and especially because you can't get the tenant to pay anything extra. That's how we got past that. We couldn't ask for a higher deposit. And if little Fluffy chews through everything, that's going to be a lot of damage. But tenants will be able to challenge the initial rent in the first 6 months of a tenancy as well. If a tenant comes and views it, sees the property is £1,000 and the tenancy gets signed, it's £1,000, and then sits around at the bar and his mate says, oh, £1,000 sounds a lot. And I think, oh my gosh, perhaps it is a lot. And then he decides, okay, I'm going to challenge this. And they can do that within the first 6 months. There is something similar in the law at the moment, but they're just going to strengthen that a little bit more. So renting with pets, I just mentioned little Fluffy, didn't I? Yeah. So renting with pets, I mean, look at that. Butter wouldn't melt in its mouth. Now, the rules are going to be a tenant must apply in writing. Now, at the moment, the rules are the tenant must apply in writing. At the moment, I think still sort of semi-legal to put in there no pets. But we always had in our tenancy agreement, you cannot have a pet unless permission has been granted. So tenant must apply in writing, and they cannot have a pet without permission. But they don't listen to that. Record keeping must show the decision. So if you say no, you need to show why, because they can run to some tribunal and say, oh, they didn't let me and I'm mentally unstable because of this. But you can refuse it based on building restrictions. For instance, if you live in an 11-story high rise and there's a lift and it just, that whole thing says no pets. They can't have dogs weeing in the elevators. You can also refuse it on allergies if you're not an investor, but you can't say no if you're an investor, okay? But if you are renting out the house and you're going overseas and you're coming back, then you could say, look, I'm coming back, but you can't have a dog because I'm highly allergic. And then pet damage, we were hoping, last time I had the webinar, we were talking about pet damage insurance, and I was really excited about it because we were hopeful that we could charge the tenant for pet insurance, because we can't charge more than 5 weeks deposit. We won't be allowed to charge extra rent under the new regime, and we can't tell the tenant to pay for the pet damage insurance. It's a bit of a blow. So the rights for tenants to request consent for a pet. Tenants have the implied right to ask the landlord for consent to have a pet. The landlord cannot refuse without a good reason. So if you have a studio flat on the 11th floor and the guy wants to have a Great Dane, that's a good reason to say no. But as long as you've got the evidence, make sure you've got the evidence, please, please. And that's why we as letting agents have got the advantage, because we keep recordings of all calls, all texts, all communications. We've got 10 years worth of communications between people. So we can always prove things. So only tenants have this right. So that's great. Everybody thinks, oh, you can't advertise properties and say no pets. But apparently you can, because only tenants have the rights to ask consent for a pet. New applicants cannot ask for consent for a pet. So I don't know if they're going to close that loophole. Let's hope not, because at the moment you can still say no pets if people come and view it and say, sorry, no, I'm not going to accept you as a tenant, no pets. The landlord will have 28 days to respond to the tenant with their decision. So if a tenant, a current tenant, has moved in and he now suddenly wants a pet, then you've got 28 days to respond. You can't just say, oh, forget about that. I just won't respond for years and years, and let's hope the problem goes away. So point 7 and 8 are the landlord database and the ombudsman. Now, they're huge fines if you're not registered. Now, this thing doesn't exist yet. I don't know if Angela Rayner has offered to go and work there, because it doesn't exist yet. It hasn't been designed yet. It's nowhere on the planet. Perhaps they're going to do the COVID app and repurpose it or something. But so the new private rented sector landlord ombudsman service is called the Landlord Redress Scheme in the bill. And landlords will have to join this before putting the property on the market. Now, this is to prevent, tenants do have problems, and then they run to the council. And this is the way that the council said, okay, we don't want to deal with this anymore. Let's have an ombudsman. So now the tenants can complain to the ombudsman about the landlord or the letting agent. So previously they only had, if they had a letting agent, they could go to the letting agent ombudsman, because we're all supposed to be members of that. And then they could complain about the letting agent not killing the rat that's strolling around in the garden or anything like that. So all private landlords will have to join, even if they use a managing or a letting agent. So because all managing agents have to be members of the redress scheme, but even if your letting or managing agent is part of a redress scheme, you as a landlord will still have to join as well. And then what the danger is, prospective, current, former tenants will be able to make a complaint to the ombudsman free of charge. So if you have a viewing with an applicant and he doesn't get the property, he can complain. If you've got an existing tenant and you don't fix something, he can complain. And if you've got a tenant that's moved out 2 years ago, he can complain. I think the time limit is 2 years. So just to summarize this, all landlords have to register, including those using a managing agent. Tenants can use the service for free to complain about landlords' actions and behaviors. And that's the same case with us now. We've got the redress scheme, and tenants can complain for free. So they don't lose anything. They can make up the biggest load of rubbish. Ombudsman will have the powers to enforce landlords to apologize. Oh yeah. Provide information, take remedial action, or pay compensation or a fine. Bet you it's the last few and not just the apologize. And it'll help the landlords to resolve complaints in the quickest, most efficient way. It does, I would agree that it does provide a platform, because if you're dealing with people, but like the council, with complaints, they just take like a one look, like compliance and fines, while the ombudsman is a little bit more human. Landlords will have access to guidance and support from the service, and I think that is because I've had the ombudsman about this rat in the garden, huge thing about this rat in the garden that I was supposed to go and kill with my own bare hands. I said, I don't have any control over this rat strolling around in the garden. And then the ombudsman was really great in advising me on what I could do. And it is expected that there will be a small fee per property owned. So it's per property, which I don't really 100% agree with, because we pay one fee for a certain amount of properties. So hopefully there'll be some sort of scaling as well, because I know a lot of people have got lots, professional landlords that are companies have got a lot more properties. To pay per one is really bad. And this will be introduced as soon as possible after the royal assent. Once again, there is no database. I don't know who's going to be working in it, but yeah, good luck to that. And then also you'll need to register on the landlord database. Now I'm a little bit more concerned about this one, because you'll need to upload your EPC, your gas cert, etc. And letting agents are already celebrating this, because you don't have to pay any marketing company to go and hunt down landlords. It'll just be all over there. So I don't know what they're going to do about data protection. I'm a bit concerned about this. But landlords will be legally obliged to register both themselves and the properties. And there will be several penalties if they market or let out a property without registering it and providing the required information. And you won't be able to get possession apart from ground 7A and 14. That is probably for the arrears and the antisocial behavior if you haven't joined this landlord database. Once again, the civil penalty is 7,000. It's their favorite figure, and it can increase up to 40,000 and even result in criminal prosecution. So for not being on that database, I don't know, I think it's quite important just to do it once they get the thing going. The decent home standards. Now, previous only social housing had it, but actually they never had it. It was actually never introduced. They were going to introduce it. Now they're going to roll it out to the private sector as well to improve quality. And it's going to be strong enforcement by council. So councils are just like rubbing their hands in glee because they got rid of all this complaint stuff and they are now going to make mega bucks with this decent home standards. So part 3 of it amends the Housing Act of 2004 to include a new system for assessing housing conditions and enforcing housing standards. And the Secretary of State has the power to specify requirements to be met by qualifying residential premises in regulations. Well, it's a mouthful and it's full of discrepancies. So on 2 July this year, the government launched a consultation on its proposals on a single decent home standard to cover both privately rented and social housing. Now, just remember, there was never anything implemented in social housing. And assuming it comes into force as per the proposals, the homes will need to meet the following 5 criteria to be considered decent. So this is how they're going to judge it. It needs to meet the current statutory minimum standard free of any serious Category 1 hazards. Now, the minimum standard has not been established yet because remember, it was never introduced into social housing. It needs to meet reasonable state of repair. Now, I don't know who's going to decide what is reasonable. But reasonable in my eyes and reasonable in a tenant's eyes and a reasonable in a council's eyes is going to be 3 totally different things. And then as the reasonable modern facilities and services. Now that also depends. It's in the eye of the beholder. What is reasonable modern and what is reasonable? I know I've got landlords that grew up when food was very scarce and they think anything is wonderful. You know, these modern millennials, they say, oh, it's got a white bathroom suite. Oh, that's dreadful. It's below modern. It can't be tolerated. And then also D is provide a reasonable degree of thermal comfort. Now, what is that? Really, what is that? What is reasonable? I mean, my colleague leaves her heating off because she doesn't want to incur high debt. I put the heating on winter, summer, all times of year. If I'm cold, it's on. So once again, it's a judgment thing. And am I in the way? E is free of damp and mold. Now that one is probably the easiest one of the 5 to, I'm out of focus. That one's probably the easiest, but then, yeah. So decent home standards, kitchen and bathrooms must be modern and functional, and homes must be energy efficient. Then comes Awab's Law. So Awab's Law, this is the little boy. He's named after Awab Ishak, the toddler who died of severe respiratory condition caused by mold in a social housing flat in which he lived with his parents. So not a private sector flat. You know, and I mean, if it looked like that, I can understand that would make you seriously ill. And that is also one of the reasons why our YouTube channel, we've recently started trying to educate our tenants a little bit more, because they come from countries where there is no mold, there's no heating, there's no condensation, and they really don't understand that they really have to clean and clean and clean to prevent it from getting to such a state that it affects your health so badly. Every property I've seen has got some degree of mold or condensation, and every tenant, you have one property that's perfect with one tenant and the next tenant's got major problems. So there's always, you know, lifestyle as well. So Section 42 of the Social Housing says to take action in relation to prescribed hazards which affects leased dwellings within periods specified in the regulations. But the regulations don't exist yet. Remember, the specified things have not been specified because they haven't had the consultation to decide on the specifics, and the regulation hasn't. So yeah, it's just one big mess. So RWOP's law has not been implemented for social housing, and the details are still out for consultation. Yeah, so consultation, regulations specified, and then the election was called, so everything was reset. The Renters' Rights Bill will extend Section 42 to the private rented sector and require private landlords to address the hazards such as damp and mould within the specified time. But the specified times have not been specified yet. And the details will be set out in the regulation after the consultation. So yeah, we're waiting for the consultation, the regulations, and yeah. So it's nearly like that database thing, isn't it? So discrimination. Now this has been coming slowly and surely. And I must say we've been implementing that. In our adverts, we don't say no DSS, and we're very careful if we say no kids. There will be no ban on allowing renting to people who receive benefits or who have children. So any current terms to that effect in the lease agreements, mortgages and insurance contracts will have no effect. So they are tackling the lease agreements, because the problem was you had a lovely tenant moving in, and then 3 months down the line they lose their job, they go and ask for universal credit. Suddenly you are in breach of your mortgage and you're in breach of your insurance. So you sit with an uninsured property, really. So it's good that all these things are going to be brought in line. But you can still turn down applicants on the grounds of affordability. And this is because Clause 40 explicitly states that landlords may still take a person's income into account when considering whether that person would be able to afford to pay the rent under relevant tenancy. Record keeping is going to be so important once again. So if you've got two tenants applying and the one's got kids and the other one hasn't got kids, you need to sort of say, okay, I decided on so-and-so because of this. And it makes you feel a little bit spied upon. Every decision could be scrutinized. So discrimination is not allowed. So you can't say no DSS. No, you can't say no kids. We do say it still sometimes. I mean, if it's like a studio flat with a steep stair, mezzanine level, you can't have a kid in there. We'll have to read the wording carefully. You can say no if the income is low, and you can say no if overcrowding. So I would say we're going to become experts at overcrowding rules and regulations. But keep records, really keep records. And, you know, rent and legal cover, once again, is going to be so important, because at least if somebody attacks your legal cover, will cover you for these type of things that you have to defend yourself against. Now, EPCs, I was going to, EPCs is one of my favorite subjects, but I don't think we have time. I would just like to say that at the moment, EPC, which is an energy performance certificate, at the moment, if it's below an E, so if it's an F or a G, you cannot rent out that property. So if you've got a property that will never, ever be a C, it might be time to sell it, and you can't sell it to an investor unless he knows something that you don't know. But the reason why the government has set the date of 2030, because they might not be in government anymore, and they just think, okay, whoever is in government can then deal with it, because it's not really something that people love them for. I know we all want to save the planet, but the rented sector is only 1/5 of all housing in the UK. So I don't know why are they targeting landlords with this EPC stuff, and 1/5 of all housing now have to be the guinea pigs of this, making homes airtight. I suppose it's because tenants are sitting there and are the victims of a bad insulated house. But I just think it's unfair if you are targeting 1/5 of housing and you insist that they improve. So more local powers. They're going to have rent repayment orders for up to 24 months. Now that's going to kill you, because if you didn't fix something in the property within the specified timeline, you know, they could, or you didn't, deposit is one of them. Deposit is already in place. So if you didn't secure the deposit, and that tenant can claim back 3 times the deposit. But then rent repayment orders are going to come on top of that, and they're going to make it 24 months. Now just imagine if you have to give that tenant back 24 months worth of rent. That's going to be a killer. Really not worth breaking the laws for. And then these environmental inspections, when we do inspections, and we do lots of inspections because you have to do inspections, because you never know if it's going to be overcrowded, or you never know if the mold is growing all over. It's really important to do those inspections. So if you ever need an inspection done, we are in the Croydon, Bromley and Sutton area, so South London and even a bit up towards Stratton. If you ever need an inspection, we've got a brilliant inspection clerk. But council, they don't need any permission. They don't need to get permission from the tenant to access the property. They knock on the door and walk in. So be careful, this HHSRS and the home standard. So the rent repayment orders, bidding not allowed, increases will not be capped, which is good, but beware of the market rent, which is like a cap. Rents won't be capped, but once again, beware of the market rent, because that is like a cap. Guarantor changes, that was an issue because they wanted to remove the guarantor after a certain time. And then they were going to bring in the superior landlord. So be careful if you are rent to rent landlord that gets the guaranteed rent from anybody. That person, if they mess up, you will be held liable. So I would just suggest always get rent and legal cover. I cannot reiterate that enough. And then make sure that you do regular inspections. 6 monthly inspections, really. You need to have 6 monthly inspections. Croydon Council is now, they hinted at getting a license scheme. The last one was shot down, so let's hope the next one is as well. Okay, so let's get to some questions. Oh, we've got the tenancy checklist. So I did mention that getting ready for this renters' rights bill, we just need to make sure that all our ducks are in a row. For instance, if there's a mortgage on the property, have you got consents in place? The landlord insurance, is the landlord not in breach of leasehold or governance restrictions? All those things. So it's in our tenancy checklist. And I will bring up a questionnaire that says, do you want our tenancy checklists, which is like a tick list, and you can just say yes or no. And if you want a one-to-one with me, spend 15 minutes just going through whatever your concerns are. If you want to invest in property, if you want to sell, if you want to rent for the first time, or if you want to expand your portfolio, then book a 15 minutes call. And then what we're offering tonight is so we usually charge a full portfolio review. We charge £230, but for anybody that's on the webinar tonight, we're offering that for free. So at the 15-minute, we will determine how long do we need for a proper portfolio review or a rent review or whatever review you need. So I'm going to launch this. So if you just say yes or no. So if you want to get the tenancy checklist, just click on yes. And if you want to schedule a call about your rental investment, plans to sell or purchase, then just click that as well. I'll leave that up for a few minutes while I go through the questionnaire. Does anybody need some more time? Okay, I'm going to end it. If you want it, just put it in the comments and Clemmy will go book you in anyway. So I'm going to end the poll now, and I'm going to, oh, here is the book a quick chat. So if you're up to it, just scan the code and book it live. I've got some slots. I don't know if I've got a slot tonight at 10 o'clock, but I dare you to try and book that slot at 10 o'clock tonight. Don't know if I've booked it out. Or otherwise, put in that. Oh, I just need to readmit Sherry. Anyway, so I'm just going to go through the questions. So Mia asked if it will be the same for the landlord side, 2 months notice. Yes, it's always been 2 months notice, Mia, and it will I think it makes it more fair that actually the tenant must give 2 months' notice, but the landlord will be prevented from giving notice because if he wants to sell it, he must wait until month 8 and give them 4 months' notice. So, no, it's not going to be 2 months' notice anymore for landlords because there won't be any way to give notice to a tenant if you decide, I just don't want to do it anymore. I've discussed the rules regarding rent arrears and selling and moving back in, and that's 4 months and 3 months. Jonathan said, with existing tenancies, say 2 years in, how much notice to sell and how? Now, if it's an existing tenancy, Jonathan, I think that it will just be the 12 months have passed, so you can do whatever you want. And I think there will be a thing that, perhaps if you want to sell, unless if they totally cancel Section 21 now, you'll have to give the 4 months notice. Yeah. But at least you don't have to wait 12 months. So do you mean we can't increase rent at all? No, I'm saying you can still increase rent every 12 months. But if the tenant delays it, you can't increase the rent beyond the market rent. You can't, I don't know what happens if the tenant doesn't go to the first tier tribunal. Don't know if they're going to fine you. Because if you just prove that, look, my neighbor charges so much and therefore I charge that much, then you've got your market rent, isn't it? There is another question here about market rent, and I'll get to that. And then who will bear the cost of the lost 3 months' rent? So, Surendra, I think you mean the 3 months when the tenant hasn't paid the rent because he's just not paying the rent. That is your rent and legal cover needs to pay that. I've had tenants there for 15 years, and in 15 years ago, those things didn't exist. So I recently bulk imported all my tenants into rent guarantee, rent and legal cover, and I've got a really good deal on that for my landlords. So they all got cover now. Beverly, can you give the property to the council as social housing? Will they take on your tenants? No. No, you'll have to get rid of that tenant because they want that property for social tenants. And if your tenants are social tenants, then perhaps you can always talk to them. But I don't think social housing is for social tenants. So they're not going to take out a private tenant. Ramon, who decides the market rate? Very good question. Council should sort out the outdated a local housing allowance, very much so. And even that list that goes on from the Bureau of Statistics, that's where they get the local housing allowance from. So it's absolute rubbish. And then Ramesh asks, how is market rent established? Well, that is just comparison. We've got tools that we compare similar properties on the market, and we don't have to stick to local housing allowance things. It's a free market, and we will compare similar properties to yours, and that's how we determine we always give a bit of discount to tenants who've been there for many years because we don't want them to up and leave and choose another property. I would always give like 5% discount, or perhaps depending on how good they are. And then Surendra, don't sell. There's too much hassle and no protection for the landlord. And that's why, I would say use a letting agent, because we go on these training courses day in, day night. Our training bill is astronomical. We have to learn all this stuff. So we can deal with it for you. Don't worry about it. Peter, is there a max period before a tribunal decision is received? I hope so. I don't think so. But it would make total sense. Surely they can't sit on it like the courts sit on these eviction things, and you wait for years to get rid of your tenant. It is really so bad. So let's hope so. Surely there should be a KPI, and do the tenants, at the moment, they're dealing only with a few cases. So I don't know how they're going to deal with the influx of cases. Do the tenants pay old rent while your rent is determined? Yes. Your tenant pays the old rent. On the current system, they pay the new rent, and then the tribunal will say, look, it's a little bit much at the moment, so give them back. But with the new system, they pay the old rent. And then Beverly, what if the tribunal agrees with my Section 13 figure? Oh yeah, they will say it stands, but it will delay. So Unfortunately, if it takes them 3 months or 4 months or 5 months to look at your figure and say, yeah, actually, we agree with you, Beverly. And tenant, you start paying, but you start paying from next month. You don't have to pay back the 6 months that Beverly's lost. So Chigbo, will this new law have any impact on the deposit process? Not as far as I know, but it's a good question because I'll have a look at that because there could be certain... I don't think so. Because a deposit is there for damage and arrears rent. So surely if the arrears rent is the arrears rent and the damage is the damage, it's not going to change anything. So I could be under correction, and it'll be nice to book a call and we can discuss this. Christine, can you change agents with same tenants when contract is renewed? Current contract ends to start a new contract, same time as using a different agent. Yes, you can, but you have to really read your terms of business with that agent, because some agents have got in there that you are indebted for them for life, which is, in their eyes, it's an unfair thing. You cannot have that. So I think what is a fair one is like giving them 3 months notice, or obviously when your tenant moves out, it's fine. But if your tenant doesn't move out, and they say, oh, but you know, this is our tenant we introduced to him, and you can't change agent while you've got that tenant, you need to pay us that yearly fee every year. So read the fine print, and it might be worth getting a bit of an expert opinion on it. No, Christine. In a house with 5 flats, there will be someone there with allergies that will be affected by a pet. Who pays the fees for dealing with a tenant who is first 6 months challenges rents? Okay, so I think it's two questions, isn't it? In a house of 5 flats. Look, I could be living in a house next to a guy that's got sheep, and I'm allergic to sheep. What can I do? I'm gonna move. So you can't control, unless you've got the whole building and you know about these things. You can't control it. So if you've got the whole building, I suppose you could say, look, I've got a guy next door that's extremely allergic, and that would be quite reasonable. But if it's a stranger and you don't know about it, you can't restrict people moving into the building. And then Jonathan's other question, who pays the fees for dealing with tenant who's in first 6 months challenges rents? You do. Well, there won't be a fee because it's first tier tribunal is free. So it's free for everybody. But if there's a reduction in rent, you're going to have to pay that tenant back because the first tier tribunal is the one whose word is final. Joint owners, Ramesh asks if joint owners have to register for this ombudsman and database. We don't know. I think they'll just have to join as one, because I can't see that you have to join. You know, it's ridiculous. I think you've got 3 owners, haven't you? I think it's as one. Let's hope so, for your sake. Nata, what happens to an existing 36-month fixed-term tenancy when the bill becomes law? Will it automatically convert to periodic tenancy on the same day, allowing me to give the tenant 4 months notice after 12 months grace? To an existing 36, will it automatically convert to periodic? Yes. No. I think that the fixed-term tenancies in existence will be upheld. But there could be some loopholes. I can see what you're aiming at here. You want to sell the property, you're stuck in a 36-month fixed-term tenancy. So you're saying, oh, 12 months has passed, I'm going to give them 4 months notice. We might have little loopholes like that we can make use of in your case, hopefully to your benefit. And then, or will the government only apply the law for newly created tenancies, leaving the existing ones unaffected? We'll have to see, but hopefully for your sake there will be some loopholes that you can make use of, and you can move back into your flat a bit sooner. Will you only have to upload before advertising a property, or will all landlords and properties currently have to be? So this is not in existence yet, but you will have to upload all your stuff before your tenancy starts. Definitely, definitely. And it might even be before you advertise. Although that's a little bit unfair, but the EPC, definitely you have to upload. So Minor damp and mold, decent home standards. Yes, well, that is why I say, you know, what is minor and what is major and what is unacceptable. We'll have to, because every property has got damp to some degree, and it just, you know, I climb in there in my house, my 1920s house, and there's always some mold to be found somewhere. And my heating is always on full blast, so surely there should be no mold. So if a property fails the repair test and needs major works to fix, say, a damp issue, what happens if property needs to be uninhabited for works? Well, that's a very good question, because we've had that situation on a previous webinar where I think, I can't remember who it was. Was it Beverly? Was it you? Yeah, so she needed the house to be vacant to do the repair, and she couldn't get the tenants to move, so she couldn't do the repair. And then the council said, but you must repair it. So it's a chicken and egg situation, and it needs careful handling. So book a call and we can have a good old chat about that, Jonathan. Decent home standard. The tenant generates damp and mold by not opening the windows and ventilating the property. She keeps blaming me. I know your tenant. But I do not live there, so what can I do? I've given a dehumidifier, even gone round there, removed the mold myself, but from the way tenant lives, it'll come back. The only way, Beverly, the only way I would suggest you do is just go remove it every 6 months and just keep a good record that this tenant is refusing to do this and giving you access and not running the dehumidifier. Look at positive input ventilation systems as well. I know we had a big talk about what systems we could use. I think Mary is an expert on this. And then under the new rules, I want to sell my property. I have a tenant who's been there for a few years. I want to have to take the tenants to court. Yeah, so if a tenant doesn't want to leave, so even under the new rules, if you give 4 months notice because you want to sell the property and they do not leave, you still have to take them to court. And then the court will say, look, tenant, you are being unreasonable. You know, this landlord is giving you 4 months notice. They want to sell, so go, please go. So Jonathan, okay, and this is the end. I can only take one more question. Okay. Potential complaining about rent enforcement. Can I get a new tenant to sign that he's totally happy with the rent? No, your tenant can sign he's totally happy with the rent and then turn around and go and complain about it. But don't worry about this, because I think decent tenants won't know about this. There's a housing shortage, and I'm sure that the rents will go up because there is a housing shortage and the rents will go up, so it will catch up. Don't worry about it, you know, unless you got this magical rent from somewhere. My letting agent finds me tenants and collects the rents. Will they inform me what is required with the renters' rights bill? Well, unfortunately, not all letting agents do what we do. They do not inform their landlords or people. I don't think they know themselves yet because it's not law yet. So they're not proactive and they're not very communicative. So choose your letting agent. I said, choose me. So let's move on because we are seriously behind schedule now. So I'm going to stop this share and I'm going to my next PowerPoint, which is number 3, isn't it? Yeah, so now we're getting to that phase where we say, we're going to talk about what are your options if you ever wanted to sell or if you decided you wanted to buy more properties. Now we've got quite a lot of investors, and let's hope they haven't dropped off because they got bored with the renters' rights bill, because not all investors buy a property to let it out. They buy properties for different reasons. And some investors don't mind getting a property with a tenant in it because they might have big plans for the house or the property and they need time to get the planning done. They can't do the planning before they've bought the house. So once they've bought the house, the tenants are in there paying the rent, they're happy. Then they can do the planning permission and all that rubbish, which takes months, years. And then once that's all approved and they got all the quotes and the builder's quotes, then they can ask the tenants to go. So sometimes it fits into an investor that wants to convert buildings or flip them. It just might not be a quick flip. Now, the housing prices vary, you know, the market changes, governmental changes, the cost of living, generation rent. People are just not saving anymore. So not many properties get bought by the younger generation. Their tax changes, their interest rate changes, there's inflation. So now there's rumors of 40-year mortgages that will spread the higher cost over longer periods and into retirement. Now, recently they've had approval, the banks have had approval to increase the lending criteria from 4.5 times the salary to 6 times the salary. So this allows people to borrow more for longer. So they'll be retiring with a mortgage. And I think that's going to bring a whole new industry into life because people will be dying with mortgages. You'll have to insure for that and all that. Affordable housing does not mean cheaper housing because the cost of materials and labor just cannot deliver cheaper housing. So the interest rates, so are we in a property crash? Well, according to some experts, 100% yes. They say interest rates have risen, there are less mortgages available, there's more stock for sale because landlords are selling because they just can't take this stuff. But I think if you are hardy and in a few years, this will all be normal. All this renters' rights bill stuff will be normal. Like 30 years ago when all this Housing Act came in, that was like, the whole thing is going to collapse. And look, we're used to it now. There are less buyers because there is less money, less people. AI is taking over jobs. I mean, things are happening. So there's definitely a downward trend in prices. Not the crash, but people are not getting what they really want. So should we wait to buy? No, don't wait to buy. Professionals make money in every market. Amateurs, they try and time the market. So what we're about to see is the biggest house price raises in a generation. Now, this is not my comment, but this is what I've heard people say in the investing world. So what does this all mean? Opportunity. It does mean opportunity. Any hardship in any market is always an opportunity for somebody. So there will be less rogue landlords, well, hopefully, less untrained amateur landlords because they'll be handing over to letting agents because they just can't deal with all this legislation. And the fines, it's just not worth it. It's cheaper to get a letting agent, a managing agent, than it is to pay a fine like that. 40,000 or losing 2 years rent, it's just not worth it. Less supply of rental properties pushing the rents up, and that's so true because landlords are selling, so there are less properties. Yeah. So more landlords are selling also means there are more bargain deals available because those landlords bought many, many moons ago. So they can afford to give it at a slightly discounted. I'm not saying you get huge discounted, especially in Croydon, Sutton, Bromley, in these areas. You won't get hugely discounted properties, but people still want to buy here because they don't want to buy up north where they don't know what type of tenant they'll be getting. You might have your house burnt down just for the insurance. So media fear will create big opportunities for the educated. Property investing and renting will be around for 10, 20, 50, 100 years. All these big corporates are buying properties. Why are they buying properties? Do they know something we don't know? So can I sell my rental with the tenant still living there? Yes. And we've been doing it. So there's no legal requirement for you to evict your tenant before selling. And what you're selling is a already made investment, or you as an investor, you are buying a ready-made investment because you've got the rental history, you can go to your bank and say, not how much rent I can get, this is how much rent I'm getting. So it's quicker and smoother transaction if the buyer is another landlord. So for a seller, it's a good thing because if the other buyer is a landlord, there's no gazumping. It's not on the open market. It's not on Rightmove. It's not on Zoopla. It's a closed list that is given to investors only. And if you want to get onto that list, book an appointment and we can see if you are a serious buyer and you've got all your ducks in a row, then you could get the properties that we have as a first opportunity. And it avoids the hassle and the cost of ending a tenancy. You'd rather have a tenant in there that is paying the rent. You've got rent guarantee insurance or rent and legal cover on them anyway. You don't have to find a new tenant. You don't have to renovate the property, because you know what a property looks like when a tenant's just moved out. It always needs work, even after a year. So avoid the hassle and the cost of ending a tenancy. And there are some other, there are some intricacies, but we are used to that. So who would buy a property with tenants? So buyers actively looking for turnkey investments. You don't always need to keep those tenants forever and ever and ever. You can do stuff with that property, but it's good to have that income coming in every month. So if you're investing, you've got the rent, you get a whole pack that you can give to your bank and say, look, this is the full history. That tenant's been in there for 15 years. The rent is up to date. The inspections are up to date. You've got the inspection report. You've got an inventory report. You've got everything. And often willing to pay more for an occupied property. You do your sums and you say, hang on, so how much is this worth? Because if I have to put in a new kitchen, a new bathroom, because there's a lovely avocado bathroom, the current tenants are happy with it. But if you have to kick the tenants out and then look for new tenants, they might not be happy with that. So great for buyers using a buy-to-let mortgages, because the buy-to-let mortgages love this type of stuff. So it avoids costly vacant periods. There's no refurb needed before selling. For the seller, you don't have to do anything to the property. It's not the property you're selling the tenancy, really. You keep your tenants happy, less the stress, and you market the property discreetly off market. You can't list it with multiple agents, because then it's not. Investors don't want to shop around and say, oh, I'm interested in that property, and then look again and it's gone because some first-time home buyer got a loan from mom and dad and bought the house. They want to know that if they put an offer in, that offer is taken seriously, no gazumping, no nothing. And it's instant rental income from day one. Proof of reliable tenants via rent records. Property is already tenancy ready, and offer lower upfront costs. So there's no reletting fees, or refurbs. As an investor, you calculate all those things. So how do we handle the process? So we do a tenant-aware evaluation. We check the rent and compliance. So if this is a property, one of our properties, well, obviously we know that it's compliant. We know what the rent is. We've got the whole history. But if it's from somebody else, we will do the whole rent and compliance check. Then it will be a quiet marketing to the investor network. And if you're part of the investor network, please speak to us, because, you can get onto our list if you are buy ready, that you can get opportunities in your email box. Viewings are handled respectfully or virtually. Now, there are not many viewings. When an investor buys a property, he doesn't go for 10 viewings. He doesn't say, oh, I don't like the walls, I don't like this. An investor is looking at the money, the size of the house. He looks at the figures. He doesn't look at the avocado bathroom suite, or I don't like pink, or I don't like. Usually no viewings. We just take videos and we send that off to the investors. And then only when they say, okay, this is an investment for me, then we arrange a viewing, just to make 100% sure that the property does exist and we're not rogue. The buyer receives the tenancy documents and the full rent history. And the sale completes with the tenant staying put, no disruption. And we just do all the documentation, switching it over from one landlord to another landlord. The rent guarantee carries on, everything goes on. That's the end of me for tonight, but we still got some questions, I think. Clemmy, did you put all the things in here? Are there any more questions about this new stuff? So once again, the tenancy checklist. Oh, I forgot something. I've got a list for home movers, suitable for tenants and home movers. And if you put guide in the comments, then we can send that to you. What else is there? This is the tenancy compliance checklist. This is really important, especially if you're thinking of selling, that you go through this, or you make an appointment and we go through this, so that you know that your property is compliant before you sell. Because if you want to sell with tenants in, that property needs to be compliant. And we make it compliant. Don't worry about if there's some gaps in there. So here, book a free chat with me. So this is the biggest property investing opportunity in a history because a lot of landlords are leaving and there's a lot of properties on the market. I love these little houses. Property is people business and a collaboration is key to success in 2025 and beyond. Our next webinar is on 12th February. And we'll choose a different subject. We'll send you the registration link for our next webinar. So it's in 4 months' time. It doesn't clash with football. It doesn't clash with any religious holidays. We've checked. It doesn't clash with school holidays. It doesn't clash with Valentine's. So book your chat here. I've got some availabilities. And then let's have a look. Ramesh, how quickly will courts act? Will there be a long queue? Is that for evictions, Ramesh? I don't know which one you mean. The first tier tribunal is not part of the court system. It's a separate thing. It's government. And there are not many people working there at the moment. So I don't know if they're going to cope with the workload. It will take a few months for the tenants to latch onto whatever shortcuts they can take. There's always a long queue at the courts. So I think it's going to be a longer queue for this Section 8 stuff. Does a deed of surrender work? Marina, I'm not an expert on deeds of surrender, but I've got somebody in the office who is. So I will get back to you. I know, Marina, you are attending the webinar on behalf of somebody who couldn't make it tonight. So book a chat with me and I will definitely find out about that. Who do you use for rent guarantee? We use various ones and we just choose the ones that give us the longest. At the moment, we're using one that gives us 15 months rent. So if the rent gets in arrears, they pay from month 2 for 15 months and they've got 100,000 legal fees. Previously, during COVID, the courts took so long that some of the rent guarantee just ran out. Oh, yes. So I just want to ask if you enjoyed this, I would love to ask you if you could do me a big favor and just give us a review of how you found the webinar, because we always need reviews, even if it's for webinars. We've got lots of good reviews from tenants, we've got a lot of good reviews from landlords and from vendors and buyers, but we always need reviews. So if you could just give me a review, that'll be great. You can leave a review using the following link. I'll close the meeting. So if you want to book a chat, so just scan this QR code. We've got a few slots available. I've sort of opened my diary for the next few days. So just to talk to people and meet them and find out what their problems are and what their plans are. We can do full portfolio reviews and we could do rent reviews and just try and make some money for you. Thank you very much. And I'm going to close the meeting now. See you again. Bye.